In ML Technology Limited and NAUREX Limited versus B.E.A.T SAM Limited and others, Mr. Daniel Alexander, KC, sitting as a Deputy Judge of the Chancery Division, refused to approve a retrospective increase of £259,069.67 to the claimant's disclosure costs budget, notwithstanding that the defendants had agreed to it. The proceedings arose from a dispute over use of the NAUREX trademark following a share purchase agreement. At the Costs and Case Management Conference, the claimant's disclosure budget was approved at £97,768. Both parties subsequently applied for substantial increases, reached mutual agreement on those increases, and submitted an agreed draft order at the pre-trial review. The judge declined to approve the increases at that stage and deferred both applications to after trial, so that the value of the additional disclosure could be assessed retrospectively. At the consequentials hearing, the claimants pressed for approval of the disclosure increase alone. The court refused, holding that costs budgeting protects third parties and the court, not merely the parties between themselves, and that mutual agreement between the parties was a reason for more intense scrutiny, not less, because the adversarial process could not be relied upon to test the justification. The court found that no evidence or argument had been advanced to explain specifically what the additional disclosure had contributed to resolving the issues, judged with hindsight after trial, and noted that the near-nil alternative dispute resolution budget lines in both parties' own precedent T schedules told against them. The burden on a party seeking retrospective budget revision was described as heavy, and it had not been discharged. Quote, "Control of costs is not only a matter between the parties, or for the parties to agree between themselves with the court merely rubber stamping them. The court must be satisfied that the budgets are appropriate, even if the parties' solicitors agree to each other's increases. That is, in part, because spending more money on litigation imposes costs on third parties as well. The more substantial the variation, the greater the justification required. The fact that the parties and their advisors are agreed that they would not, or not significantly, challenge each other's proposed increased budgets can mean that the court needs to examine the basis for the variation with more rather than less intensity."
For a detailed summary of this decision, visit tmclegal.co.uk.